All right, good day, ladies and gentlemen. This is Professor Brenton Boyce. This is courtroom testimony, CRJS 260. Of course, I'm about to lecture from chapter 6 of our textbook. Our textbook is Winning Courtroom Testimony for Law Enforcement Officers by Matthew J. Medina. Now, let's go ahead and jump into it. Chapter 6, we're going to be talking about eyewitness testimony. Now, the one thing about eyewitness testimony is it is the source of a lot of convictions, and it's also the source of a lot of wrongful convictions. As an eyewitness in the case, if you're going to be testifying, specifically on cross-examination, you're going to have to expect to be essentially questioned about or doubted about your perception, what you saw, what the situation was when you saw it, whether or not it's true. So it's not even as much about lying or telling the truth or lying, but it's about perception. Did you really see it that way? Do you remember? Wasn't it very traumatic? Are you sure you remember it the right way? So let's talk about it. In many cases, the most important prosecution witness is the eyewitness. The prosecution may call you to testify as an eyewitness to any relevant action or omission committed by the defendant or other person. The prosecution may also need you to testify as a circumstantial witness. The circumstantial witness can testify to actions by the defendant or another person that, along with others, prove the defendant's guilt or prove some fact relevant to the case. So I want you to know the difference between um, regular, what I call regular eyewitness testimony and circumstantial eyewitness testimony. Um, an eyewitness may testify that he saw the defendant shoot the victim at point blank range and then flee in the alley. That is what they saw. That is not circumstantial. A circumstantial witness may testify that she did not actually see the defendant shoot the victim, but she did see the defendant running through the alley and observe him toss a handgun into somebody's backyard seconds after the victim was shot. So there's definite eyewitness testimony that says I saw this person do something specific, as opposed to a person that's testifying that essentially to information that essentially puts a person at a place where they can do something. That's what we call evidence of circumstance or circumstantial evidence. It doesn't for sure say that a person did something, but it may put them in a position where you can say they were there when it happened or close in time to when it happened. So you see the difference. So the prosecutor is going to ask questions that will highlight your three witness capabilities. First, the prosecution will show that you had the ability to perceive the events that you witnessed accurately. So you're going to ask questions that bolster your ability to see or perceive. It might, sometimes you don't testify to what you see all the time. Sometimes you testify to what you smelled or what you heard. So eyewitness testimony, we call it eyewitness because it's what you're seeing, but eyewitness testimony is what you observe with your five senses. So it's not just what you see; it's what you hear as well. Um, Second, the prosecutor will try to show you that you can remember. Will try to show that you can remember. So it's what you saw, your ability to see it, that you remember it accurately, and then third, you may be asked to. Then third, the prosecutor will try to show that you can talk about it um, in a meaningful way. So three things. So the first thing they want to do is bolster your ability to have observed or perceived what you're testifying to. Second is that you remember it accurately, because of course in trial it's always after it happened, right? So you're being asked to come to court and testify about something that happened in the past. Sometimes, especially in law enforcement, you may not have to come testify about your case for a year or more in certain situations, definitely at least months. So you're going to have to recall information. Now, in law enforcement they're allowed to write narratives, and that's what they do. People don't realize a large part of law enforcement is not just arresting people, but it's also taking notes. People don't realize law enforcement officers have to do a lot of writing. So it's not just walking the beat, arresting people, and going home. You walk the beat, you arrest someone, and now you got to write up a 4-page report about what happened, what you saw, and that's you're allowed to, as a law enforcement officer, to use that to refresh your recollection, because of course law enforcement officers interact with thousands of people, right? That's literally their job to interact with people, and arrest people. So you think about how many arrests a law enforcement officer might make in a month, or how many interactions they have with people within a month, and now they have to come testify and remember something specific. So they are allowed to refresh their recollection with their own notes. As a matter of fact, as the opponent in cases against law enforcement officers, a lot of times their notes can be used to cross-examine them or to impeach them, because sometimes they get creative and they want to say stuff outside of those notes. So in that situation, the court kind of comes to the situation where it's like, do we trust what the court what you're saying in court now, or do we trust these notes that you essentially had to take, and you took them the day or right at the time when the event you witnessed happened. So what do we trust? What you're saying today, or what you said right there when it happened? Nah, they close at 7. Yeah. All right. Sorry about that, y'all. So yeah, what was that? Okay, so those notes can be used to refresh recollection. So it's about the three things that the prosecution or the person that's calling you, the litigant party that's calling you, the three things they want to get out of you, or they want to show when you testify as an eyewitness, is they want to show that you had the ability to perceive, and that you saw what you saw, or perceived what you perceived clearly. 2, that you remember it correctly. And then 3, that you can discuss it and you're able to talk about it in a meaningful way. So 3 things. Now, okay, all right. What? So sometimes you get questions like, "What is it about the situation that caused you to take notice?" So of course, as a litigant in cases, we don't want to just jump in and ask you what happened. Sometimes a person will be asked, what made you take notice of what happened? Like, what brought it to your attention? What was going on that night? So they want to kind of lay a what would I say, a foundational kind of lay the foundation for why you are even in that position in the first place to have seen it, and what brought it to your attention. That makes the story a little bit more palatable, or palatable to the listener or to the jury. Um, they say it all happened so fast. Of course, time is the enemy of accurate perception. A lot of times when you see things, that may be the most serious thing, the craziest thing you ever saw before, right? Or you've ever witnessed before. You may not only be an eyewitness in the case, you may be the victim as well. So that gun is pointing in your face and you got robbed. So if you're staring down the barrel of a gun and you don't know what the person on the other end of that barrel is going to do you really have time to accurately look at their face? And then so it's happening fast, and it's also very traumatic, right? And that's where we get to the part, where they say, "Weren't you scared?" There are many factors that contribute to a witness's accurate perception of events. There are some that both the defense and the prosecution use to show your ability to perceive the events that happen. Factors like anxiety, fear, nervousness, and excitement can affect a person's ability to accurately perceive events. In addition to the environmental stresses, such as obvious factors as alcohol or drug intake, were you drinking when you saw that fight happen at the party? Um, Also, anxiety-producing effect of crime is also a popular topic of defense assertions that a witness's perception is questionable. And in real life, what I will say, witness perception is questionable. Eyewitness testimony, they get it wrong a lot, especially when they identify people and say that is the person I saw. Especially when it's cross-racial identifications, because sometimes our ability to see someone and know what their facial features are, a lot of times that is based on culture. as a black man, of course, I'm around black people more than I am people of other races, just by virtue of being in my house around my wife, or at family events around everyone that's pretty much black. Um, I know my cousin Mike got a big nose, right? I know he, I know he got big old lips, and so but so in other cultures, some of those phenotypes and facial features aren't what they see every day. So of course, if a white guy robs me, um, and then 3 months, then a year later, I have to, or I'm asked the same night to now, point this person out in the lineup. Am I really going to be able to do it accurately? Now it's different when you already know someone. So if there's someone and they commit a crime and you see it, you're able to recognize them because you know them already. So there's a difference. But in certain situations where you're confronted by someone you don't know, and you see something that happens, are you really going to accurately be able to identify this person on a cross-racial basis? And that's been a lot. There's been a lot of overturned convictions. Matter of fact, there was a famous a rape case that happened. I want to say it happened here. No, there was one that happened in North Carolina, but there was another one that happened. And I want you guys to look up the Innocence Project. That is an organization that they go in and look at kind of iffy court cases. Of course, people that are in jail write letters to them like, "Hey, look at my case. I didn't do it. Look at the evidence." And they go through and they reopen cases. They look at everything and they question whether this person is guilty or not. They look at the evidence. They go question people, and a lot of times, because their new technology has been developed where they can really pinpoint who did what because of DNA evidence, stuff they didn't have back in the day. Now they're able to go back and overturn cases. There've been a lot of people who've been wrongly convicted. And this one guy was wrongly convicted of a rape. I think it was a kidnapping and rape case. White female. He was a black male, and she pointed him out in the lineup. And what's crazy, the guy that actually did it, years later after this guy had been in jail and the Innocence Project got involved, the guy that actually did it actually had already had a rap sheet for rape. This guy did not. He was just a regular guy. He had a couple petty crimes on his record, but that was pretty much it. So once he gets exonerated based off the fact that his DNA was nowhere at the crime scene or on this lady. But when they looked at the evidence that they pulled, they realized that the DNA of a person that was there and in that area at the time and happened to already be in prison for other rapes. They linked him. They actually linked, and they actually, honestly, they kind of looked alike. So now to black people, we may say, they don't really look alike. They're just both light skinned. But you got to think from a person that's not socialized in our race and not always around us. They may not know the difference between me and someone else that's just a brown skinned black man with glasses. So it doesn't mean it has anything to do with any racism, because black people, if we're put in the same situation, we will probably misidentify people of other races as well. So but it is a common occurrence, and just think about how often you look at the news and cases are getting overturned. Think about last decade. If you go, even if you go through your new Facebook news feed, you see something almost every day about, oh, this person gets released from jail. He wasn't the person that did it. And back in the day, you didn't have a lot of technology, so you literally only had what someone said. I saw him. It was him. And that's back then. That was enough evidence. That was all they needed. Details. Of course, if you're an eyewitness, the more details you're able to testify about, the more believable your testimony is going to be. So it's not just it's a black guy with glasses. No, it's a black guy with a Seattle Timbers forest green soccer jersey on. It was Adidas brand. And he was sitting. He had on the wall behind him. It had a Monte Cristo Cigar Company logo. I remember seeing that guy. I'll never forget. He had glasses and nappy hair. That's different, right? That's giving specific details. Like I tell my clients, I always say the devil's in the details. If I'm preparing my client or any witness on my side to testify in court, I want them to be differentiated from the other side, because 90% of cases, especially in district court, I call it Walmart court, it's just a whole bunch of what someone else said versus what another person said, or what they call he said, she said, right? So very seldom in district court, these misdemeanor cases, assaults and stuff like that, very seldom is there any physical evidence. You just have one person that ran down to the magistrate's office and they got there first, and they were able to tell their story, whether it was real or fabricated, but they were able to get it out first. And because they got it out first, they have an advantage. So now I get a person that comes to my office and they're trying to defend themselves again in this situation where they essentially didn't make it to the magistrate's office first. So now we're in court, and the basis of the evidence is just what this person said happened versus what my client said happened. All testimonial. There's nothing, a lot of times, sometimes you might have a person take a picture of a bruise. Yeah, this is where he hit me right here. But even that, you can't really corroborate it. Even if it's timestamped, you still, who said that my client was the one that did it? You. So it still all comes down to what another person is saying happened versus what another person saying didn't happen. So the way I like to differentiate my client is I tell my client, give details. Sometimes a person may get on the stand and just say, yep, he hit me, that guy. But if my client can say, yeah, I remember that night, it was June 15th, it was a little bit warm outside, I wore like a light, so I wore like a light t-shirt, we were outside chilling, and I remember this guy walked up, he was drunk, and he had on flip-flops, and I was like, well, he's drunk and has on flip-flops, he's going to fall, he's not very steady on his feet. So just that little part of testimony right there, that's way different than the first example I gave, right? There are more details. So in a case that's 100% about what one person says over what the other person says, who are you more likely to believe as a juror? You're going to believe the person that was able to give details. So the devil is always in the details. So I like witnesses that give details. So as an eyewitness, you're going to be much more believable when you're able to give details. And in law enforcement, you're going to be able to narrate and write down those details right in the moment it happens. So after the event happens, you show up to the scene, you're going to have to give a narrative. You're going to have to write things down. And in writing things down, you're going to be able to bring that back up. You're going to be able to use it. You're going to be able to use it later on to refresh your recollection. So, in review of Chapter 6, you have the ability to perceive the events that you witnessed accurately. You got lighting conditions that may be questioned, weather conditions, duration of observation, like how long you saw it. If it's something you saw very quick, then you're how do you know what you saw? It happened quick. It happened in the blink of an eye. Are you sure? How close you were to the incident? For what angle did you observe the incident? Was the scene moving or stationary? Were you moving or stationary? Was there anything blocking or partially blocking your view? Was there a time where you lost sight of the person or the event that took place? Did you take your eyes off of it, then come back to it? Do you actually remember what you perceive? Remember, we talked about the three things. We talked about the ability to perceive accurately. Do you remember it? And then the third is, are you able to talk about it? In other words, are you able to communicate what happened? That's what it's about to say next. You can talk about these events now in a meaningful way. Why was your observation significant at the time? What about that situation made you remember it, or made you see it, or notice it, or take note of it? Time, of course, is the enemy of accurate perception. By the time you get to court, a lot of times it's going to pass. And you'd be surprised how much you forget minor things that end up being important, and may be the basis for a good impeachment on cross-examination when you testify. The number of details that you can accurately remember and describe makes a difference. As I said before, the devil is in the details. So that is Chapter 6. So once again, make sure you're reading the book. My lecture is nothing more than a supplement to your reading. So you need to read. And once again, also, at the end of Chapter 6, let me see if you can see. Of course, you got the questions, right? And you flip the book over, and you get the answers to the questions at the top of the page, right? If you do that for every chapter, you're going to be well prepared for my quizzes. So just continue to read the information and do that, and you'll be just fine. But that's it for chapter 6. So you guys take care.